Welcome to another lecture video for Law 20023, Business Laws and Regulations. This is a continuation on our discussion of the Revised Corporation Code of the Philippines. Particularly, for this lecture video, we will discuss corporate dissolution. Corporate dissolution. What is dissolution? This is not the first time that we will encounter the term dissolution. We have already defined dissolution sa law on partnership natin. But in the corporate setting, dissolution is the extinguishment of the corporate franchise and the termination of the corporate existence. So very similar doon sa, not really similar, pero yung dissolution sa partnership, if you may recall, pertains to the change in the relations among the partners. Okay, dito, pag sinabing dissolution sa corporation, it pertains to the extinguishment of the franchise. Sabi franchising authority to exist as a corporation, parang ganyan, granted by the government kasi nga nag-comply ka with the requirements of the Revised Corporation Code. So yung binigay niya sa yung grant, yung buhay na binigay niya sa iyo to exist as a corporation, ang tawag din ay corporate franchise. And when a corporation is dissolved, it ceases to be a juridical entity and can no longer pursue the business for which it was incorporated. However, it may continue as a body corporate for another period of 3 years from the time it is dissolved, but only for the purpose of finding up its affairs and the liquidation of the assets. So just like yung ating partnership dissolution, merong mga limitations as to the authority of a partnership na na-dissolve na. So pwede din siya binding pa rin yung mga contracts na i-enter niya, yung mga transactions after the dissolution, as long as, if we recall, as long as those contracts or transactions ay continuation na ng mga existing na contracts or necessary for the winding up of the partnership affairs. Under the Corporation Code, we have three ito pero sige two ways by which a corporation may be dissolved. So we have voluntary dissolution and involuntary dissolution. Madali din namang intindihin pag voluntary. So siya, upon the instance of the corporation. Pag involuntary, hindi. So ito, voluntary dissolution. So may dalawang uri dito. Voluntary dissolution where there are no creditors affected and voluntary dissolution where there are creditors affected by the dissolution. So for the first portion, we will be discussing voluntary dissolution where there are no creditors affected by that dissolution. So if dissolution of a corporation does not prejudice the rights of any creditor having a claim against it, the dissolution may be effected by majority vote of the board of directors or trustees and by a resolution adopted by the affirmative vote of the stockholders owning at least majority of the outstanding capital stock or majority of the members of a meeting to be held upon the call of the directors or trustees. So merong voting requirement dito. So majority. Voluntary dissolution yan, voluntary upon the instance of the corporation. So majority vote on the part of the board of directors or board of trustees and majority vote then on the part of the stockholders. Applicable lang yan if there are no creditors affected. We will learn later on na mag-iiba yung voting requirement if there are creditors affected. So majority vote on the part of the board and 2/3 vote on the part of the stockholders or members. So, sabi dito, merong meeting dapat called for that purpose. To decide upon the issue of whether or not i-dissolve na ba yung corporation o hindi. At least 20 days prior to the meeting, notice shall be given to each shareholder or member of record personally by registered mail or by any other means authorized under its bylaws, whether or not entitled to vote at the meeting, in the manner provided in Section 50 of the Revised Corporation Code, and shall state the purpose of the meeting, and shall state that the purpose of the meeting is to vote on the dissolution of the corporation. So malinaw na binanggit dito, and we have repeatedly repeatedly citing it, ulit-ulit talaga natin binabanggit ito, na sa ASIMID, di ba? Sa ASIMID, may mga decision making, no? May mga decision yung corporation na even non-voting shares, even those shares who are not entitled to vote may vote. Yung letter D sa ASIMID ay dissolution. Kaya malinaw dito, binanggit niya, whether or not entitled to vote at the meeting, they are they may they may participate in the decision of whether or not the corporation should be dissolved. Notice of the time, place, and object of the meeting shall be published once prior to the date of the meeting in a newspaper published in the place where the principal office of said corporation is located, or if no newspaper is published in such place, in a newspaper of general circulation in the Philippines. So if you will observe, ipapublish mo pa siya, you are notifying the public na mayroong, na itong corporation to, notice hereby given that that the stockholders of the XYZ corporation will have a meeting, lagay mo yung time, yung place, object, for the purpose of dissolving or deciding upon the issue of dissolving the corporation. So that is once lang, prior to the date of the meeting. Again, if there are no creditors affected, mag-iiba yung publication requirement. So dito meron siyang newspaper of local circulation lang. No? Kahit dun lang siya sa city or municipality, kung saan located yung principal place of business ng corporation, okay na yun. Pero kung wala daw newspaper of local circulation, you can make use of a newspaper of general circulation. Tandaan niyo may mga diary na pang may specific na localities lang sila available. Doon lang sila nagpa-publish. At meron din namang mga newspaper na buong Pilipinas na available siya. So local circulation or general circulation. So ito, verified request. So hindi siya petition, request lang siya. A verified request for dissolution shall be filed with the SEC. When we say verified, it must be under oath. It must be under oath. Ibig sabihin sinumpaan yung request. Nanunumpa ka na yung mga nakasaad doon sa request ninyo ay totoo. At kapag napatunayan na ikaw ay nagsisinungaling doon sa request mo na yan, verified request mo na yan, you are exposing yourself to criminal prosecution for perjury or pagsisinungaling. Ayaw naman syempre ng SEC na mag-file ka ng request stating na gusto na ninyong ipa-dissolve yung corporation, pero puro kasinungalingan lang naman pala yung nakalagay doon sa request, particularly the fact na walang creditors affected by your request for voluntary dissolution. Again, sa verified request, sinumpaan yan. Paano ba sasampaan? You have to appear before a person authorized to administer oath. So, but pwede na yan sa notary public because notary publics are authorized to administer oaths. So, yung verified request for dissolution na yan, ipa-file mo yan with the SPC. And the request shall state the following. First, the reason for the dissolution. Second, the form, manner, and time when the notices were given. Yung mga discuss kanina. Yung 20 days notice, yan, paano mo siya ginawa. By registered mail ba, personal ba, etc. Nakalagay yan. Form, manner, and time when the notices were given. Names of the stockholders and the directors or members. And trustees who approved the dissolution. Siyempre, nag-meeting kayo. May mga nag-approve ng dissolution ng proposal for the dissolution of the corporation. Ilista mo daw yung mga names ng mga stockholders and directors or members and trustees who approve the dissolution. The date, place, and time of the meeting on which the vote was made, yung actual meeting, kung anong kailan siya naganap, anong oras naganap, saan naganap yan. Details of the publication, yung previous na binanggit ko, whether local circulation ba yan or general circulation. And together with that verified request for voluntary dissolution, the corporation shall also submit the following to the Securities and Exchange Commission. A copy of the resolution authorizing the dissolution. Yung resolution board yan, board resolution or a board resolution by the board of directors or resolution by the board of trustees. A copy of the resolution authorizing the dissolution certified by a majority of the board of directors or trustees and countersigned by the secretary of the corporation, corporate secretary. Siyempre, di ba, ang required vote nga natin is majority vote of the board of directors or trustees. So, dapat yung board resolution na yan, since board resolution nga siya, dapat nakapirma yung required vote, which is nga the majority vote of the members of the board of directors. It is also required that the secretary, corporate secretary should countersign that board resolution. The corporation, number 2, proof of the publication, as mentioned, and a favorable recommendation from the appropriate regulatory agency when necessary. Si mga public interest corporation, paulit-ulit kong binabanggit since the start of the discussion ng corporation code, yung mga bangko, insurance company, non-stock savings association, lending companies, holding companies, etc., etc. As long as merong government agency na namamahala or nag-govern sa inyo, you have to obtain a favorable recommendation or a certificate of no objection from that regulatory agency. Within 15 days from receipt of the verified request for dissolution and in the absence of any withdrawal within the said period, so pwede mo lang bawiin itong verified request mo na yan, the SEC shall approve the request and issue the certificate of dissolution. The dissolution shall take effect only upon the issuance by the SEC of the certificate of dissolution. Wala namang kailangan ng gawin kasi wala namang creditors affected by the verified request for voluntary dissolution by the corporation. So within 15 days, mag-i-approve niya ng SEC yan. Now, application for dissolution of banks, banking, and quasi-banking institutions, pre-need companies, insurance companies, trust companies, non-stock savings and associations, pawn shops, and other financial intermediaries shall be approved by the SEC unless accompanied by a favorable recommendation by the appropriate government agency. Hindi ko na kailangang i-discuss pa yun further. And when the dissolution of a corporation may prejudice, ay iba na pala. Yun na pala yung last one. Okay? So, lilipat tayo ngayon doon sa voluntary dissolution of corporations, pero creditors are affected. So, iba yung procedure kapag gusto na ng mga stockholders, ng mga board of directors na i-dissolve yung corporation, but as a result of that proposal to dissolve the corporation, merong mga creditors na maapektuhan. Okay? So, when the dissolution of a corporation may prejudice the rights of any creditor, a verified petition for dissolution shall be filed in the SEC. So parehas verified yan, pero yung pleading o yung document na ipafile ninyo ay magkaiba. Kapag walang creditors to be affected by the voluntary dissolution, it is a verified request. Pero pag pag may mga creditors to be affected ng proposal to dissolve, verified petition. Dahil petition siya, it will be heard. Magkakaroon pa ng hearing dyan sa verified petition. But the request, since request lang naman yan, at wala namang maapektuhan, then ginagrant yan ng SEC. The petition shall be signed by a majority of the corporation's board of directors or trustees. Diba, since yun yung voting requirement. Verified by the president or the corporate secretary or any one of its directors or trustees. And shall set forth all claims and demands against it. Kasi nga, sabi nila merong creditors affected. So you have to identify ano yung mga claims na yan, ano yung mga demands na yan, which will be affected by your proposal to, or your petition to dissolve the corporation. And thus dissolution was resolved upon by the affirmative vote of the stockholders representing at least two-thirds of the outstanding capital stock or at least two-thirds of the members at a meeting of its stockholders or members called for that purpose. So dito, malinaw na iba yung voting requirement kapag merong creditors to be affected by the dissolution of the corporation. Again, to compare or to contrast rather, yung voluntary dissolution where there are no creditors affected, majority on the part of the board, majority on the part of the corporators. In case of voluntary dissolution where there are creditors affected, majority vote on the part of the directors or trustees and two-thirds vote of the outstanding capital stock or of the members. Then the petition, just like the request, shall state the following, the reason for the dissolution, so parehas sila doon. The form, the manner, and time when the notices were given, same sila. And the date, place, and time of the meeting in which the vote was made, same sila. Then the corporation, together with the petition for voluntary dissolution, shall submit to the SEC the following. A copy of the resolution authorizing the dissolution, certified by a majority of the board of directors or trustees and countersigned by the secretary of the corporation, same siya sa request, and a list of all the creditors na wala doon sa request kasi nga ang claim doon sa verified request ay walang maapektuhan na creditors. Dahil sa verified petition, sinasabi mo na merong mga maapektuhan na creditors, you have to provide the SEC with a list of all the creditors to be affected by the plan to dissolve the corporation. If the petition is sufficient in form and substance, the Commission shall, by an order reciting the purpose of the petition, fix a deadline for filing objections to the petition, which date shall not be less than 30 days, nor more than 60 days after the entry of the order. So sabihin niya, titignan niya muna, examine muna ni SEC kung sufficient ba in form and in substance yung verified petition for voluntary dissolution. If yes, if no, i-refuse niya yan. Ibabalik niya sa corporation. If yes, the SEC shall issue an order. Then i-recite niya ngayon in that order the purpose of the petition, which is, again, for the voluntary dissolution of the corporation. And then the SEC shall also fix in that order a deadline for filing objection. Since meron mga creditors affected, the order shall include na kayong mga creditors na to, if you object, kung ayaw ninyo, na ang petition na ito ay maproseso o matuloy, dapat mag-file kayo ng objection to the petition. You oppose the petition. Pero meron niyang pre-period. Yung period shall not be less than 30 days nor more than 60 days upon the entry of the order. Yung order allowing the petition. Before such date, a copy of the order shall be published at least once a week for 3 consecutive weeks in a newspaper of general circulation published in the municipality or city where the principal office of the corporation is situated. Or if there is no such newspaper, then in a newspaper of general circulation in the Philippines. And a similar copy shall be posted for 3 consecutive weeks in 3 public places in such municipality or city. So medyo mas matindi yung requirements pagdating sa voluntary dissolution where there are creditors affected. For the very reason that there are creditors affected. So doon sa no creditors affected, once lang siya ipapublish. And in fact doon, hindi nga siya kailangang i-post. Walang posting requirement. Dito meron. 3 consecutive weeks siya in 3 public places. So, ilalagay siya sa City Hall, sa Barangay Hall. Doon sa place kung nasaan yung opisina ng corporation, pwede doon. Kung saan-saan, make it public. Kasi nga, you are announcing to the creditors of the corporation na we are planning to dissolve the corporation. So they have to be notified in all manners available by sa newspaper or by posting it dun sa mga bulletin boards. Upon 5 days notice, given after the date on which the right to file objection as fixed in the order has expired, the SEC shall proceed to hear the petition and try any issue raised in the objections filed. If no such objection is sufficient and the material allegations of the petition are true, the SEC shall render judgment dissolving the corporation and directing the disposition of the assets as justice requires and may appoint a receiver to collect the assets and pay the debts of the corporation. So dito, di ba meron mga creditors affected, nag-publish ka, nag-post ka. So pag may mga objections, di ba, in order mo sila o within 30 days to 60 days, mag-object na kayo. Mag-oppose na kayo. Pag may opposition na nag-file, the SEC will hear, pagkakaroon ng hearing, bakit mo ba sinasabi na kailangan i-oppose itong dissolution? O sabi ng oppositor, ganito daw, o corporation, ano naman masasabi ninyo? Ganun yung mangyayari. So based on the evidence to be presented sa SEC, pero admin hearing lang naman yan, hindi naman yan court full-blown trial. Admin proceeding ito. Then based on the evidence presented, and upon, syempre may discretion yung SEC dyan, syempre the SEC is in the best position to determine the propriety of the application to dissolve, magre-render siya ng decision. At yung decision namin, we are granting the voluntary dissolution or we are denying the voluntary dissolution. Pero pag walang objection, then ano daw gagawin? The SEC will render judgment dissolving the corporation and it may even appoint a receiver. Yung receiver siya yung para mag-act as administrator ng corporation in the process of dissolution. So collect na yung assets and babayaran niya yung mga utang. The dissolution shall take effect only upon the issuance by the SEC of a certificate of dissolution just like doon sa request for voluntary dissolution where there are no creditors affected. So hanggat hindi nag-i-issue yung SEC ng certificate of dissolution, hindi na-dissolve ang corporation. Okay, so we have voluntary, involuntary. Voluntary, where there are no creditors affected. Voluntary, where there are creditors affected. So ito, dissolution by shortening the corporate term. Ito naman, you can dissolve the corporation by filing an application with the SEC to shorten the corporate term. So voluntary din siya. A voluntary dissolution may be effected by amending the articles of incorporation to shorten the corporate term pursuant to the provisions of the revised corporation code. A copy of the amended articles of incorporation shall be submitted to the SEC in accordance with the revised corporation code. So dito, parang ang magiging discussion na lang. Diba, for example, in perpetuity yung buhay ng corporation mo, let's say 50 years. Then after 10 years, gusto niya na siyang i-dissolve. What you can do, according to this provision of the revised corporation code, is to apply for the shortening of the corporate term. Mag-apply kayo by amending the articles of incorporation. So nakalagay diba sa articles of incorporation yung term ng life ng corporation. You can apply for the amendment of that provision stating instead of perpetuity or 50 years, the life of this corporation is only 15 years. So umikli siya ngayon. Pag umikli siya, di terminate yung buhay niya, di ba? Mag-dissolve siya. Or if you want 10 years, sinakto mo na, mag-dissolve siya. Upon the expiration of the short-term term, as stated in the approved amended articles of incorporation, the corporation shall be deemed dissolved without any further proceeding, subject to the provisions of the revised corporation code on liquidation. In case of expiration of corporate term, the dissolution shall automatically take effect on the day following the last day of the corporate term, stated in the articles of incorporation as amended, without the need of any issuance from the SEC of a certificate of dissolution. So unlike the first two situations na discuss natin, yung voluntary dissolution, where there are creditors and where there are no creditors affected, yung effectivity nung dissolution is upon the issuance of a certificate of dissolution. But in case ang dissolution is affected by shortening the corporate term, automatic siya. You don't have to wait for the certificate of dissolution before you consider the corporation dissolved. Siyempre, meron pa rin process of liquidation. Pero as of the time na na-terminate yung buhay ng corporation pursuant to the shortened corporate term, automatic na considered na siya as dissolved. Okay, so we have here involuntary dissolution naman. Actually, yung first stream ng voluntary dissolution yun, ito involuntary. Ibig sabihin, hindi siya nag-a-apply, hindi nag-petition, hindi nag-request, hindi nag-a-amend. Pero may mga grounds under the law to consider that corporation as dissolved. A corporation may be dissolved by the SEC motu proprio or upon filing of a verified complaint by any interested party. So dito, pag sinabing motu proprio, it is upon the instance of the SEC. Walang nagreklamo yung SEC mismo na nasasabi, ikaw dissolved ka. Or upon filing of a verified complaint. Sa iba naman to. Nakatatlong document tayo pagdating sa dissolution. Voluntary dissolution, walang affected na creditors, verified request. Voluntary dissolution may affected na creditors, verified petition. Then, involuntary dissolution, siyempre hindi upon the instance of the corporation ito, upon the instance of a creditor or any other interested party, ang ipafile nila ay verified complaint. Okay? The following may be grounds for the dissolution of a corporation. First, non-use of the corporate charter as provided under Section 21 of the Revised Corporation Code. We have discussed this before. Nabigyan ka na-issuehan ka ng Certificate of Incorporation or Certificate of Registration by the SEC, pero wala kang ginawa. Hindi nga kayo nagbotohan ng corporate officers. 5 taon yung gawin yan, then it may be a ground for involuntary dissolution. Continuous inoperation of the corporation as provided under Section 21. So ito, nagsimula kayo, pero huminto bigla, and then for 5 years, hindi nag-operate. Upon receipt of a lawful court order dissolving the corporation, syempre, inutos ng korte na mag-dissolve kayo. So, dissolve kayo. Upon finding of by final judgment that the corporation procured is incorporation through fraud. So merong nag-file ng co-warrant of proceedings, co-warrant ito yung action to question the legality of a corporation, yung life ng corporation dito. And sabi ng court, oo nga, no? Valid, tama yung pagkaka-file ng petition for co-warrant to. May pamamaking nagaganap dito. Kaya na-issue yung certificate of incorporation. May fraud involved. Upon finding by final judgment that the corporation was created for the purpose of committing, concealing, or aiding the commission of securities violation, smuggling, tax evasion, money laundering, or graft and corrupt practices. So ito, the corporation is merong illegal purpose. Illegal purpose yan. Upon finding of a final judgment, hindi yung hula-hula lang. Kasi criminal case ito, criminal violations ito. So dapat may final judgment for this one. Again, if upon finding of final judgment, the corporation was created for illegal purposes, then it is a ground for the involuntary dissolution. Obvious naman, hindi man pwedeng papayag yung SEC na sabi na nga nalaman na hatulan na nga ng korte, final judgment, na siya ay created for a legal purpose, tutunganga lang ng SEC. Siyempre hindi. They have to order the dissolution of that corporation. Or the corporation committed or aided in the commission of securities violation, smuggling, tax evasion, money laundering. So dito, hindi nakalagay yun as purpose nila, pero they committed. Kahit wala nang committed. They committed criminal acts. Kumbaga. Again, working under the same principle, the corporation, the SEC, cannot remain silent on this one. Repeatedly and knowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its directors, trustees, officers, and employees. So self-explanatory naman. If the corporation is ordered dissolved by final judgment pursuant to the ground set forth, yung mga enumerate ko, yung assets and after payments of the liability shall, upon petition of the Securities and Exchange Commission, with the appropriate court be forfeited in favor of the national government. Since, yun nga, ang tawag dito, engage in illegal activities and corporation, pupunta sa gobyerno yung assets niya. Pero mabayaran mo na yung mga utang. After mabayaran yung utang, kung ano man yung maiwan, it may be forfeited in favor of the national government. National talaga. Walang, although indirectly may makakuha pa rin yung local government. Yeah. Okay, appropriate court, meron tayong tinatawag ng mga commercial courts. Obviously, pag sinabing commercial courts, ang hinahandle nilang mga kaso ay mga commercial cases. So, yung mga intra-corporate disputes, mga derivative suit, yung discuss ko sa previous lecture videos, no, kapag may derivative suit involved, sa commercial court mapupunta yan. If meron intra-corporate dispute, sa commercial court mapupunta. The forfeiture shall be without prejudice to the rights of the innocent stockholders and employees for services rendered and to the application of other penalty or sanction under the revised corporation code or other law. Siyempre, if you are an innocent stockholder, wala ka nang talagang ginagawa, you did participate sa mga illegal acts or you did not know of those illegal acts, siyempre, dapat hindi ka madamay dyan sa mga yan. So if you have claims against the corporation, even if you are part of the corporation, dapat i-honor pa rin ng korte natin yun. Wala ka naman kinalaman doon. Good faith. The SEC shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to the involuntary dissolution of companies under the special regulatory jurisdiction. So the SEC, ganun pa rin dahil ito ay complaint, pero dapat notice, no, doon sa mga regulatory agency prior to the involuntary dissolution with respect to public interest corporations. Okay. So, hindi lang yung SEC o yung court ang mamamahala doon sa involuntary dissolution. Dapat, kung governed siya by the BSP, kasali yung BSP. Kung governed siya ng Insurance Commission, dapat kasali yung Insurance Commission. Okay. Anong sunod na mangyayari? Corporate liquidation. Liquidation, ito yung process by which yung actually ginawa niyo naman to sa, hindi ko alam kung saan subject nyo na ito nakukuha ngayon sa accounting. Pero meron kaming corporate liquidation. Free assets, no? Secured, no? May secured liabilities, no? Unsecured obligations, yung pag-matching mo partially secured, no? Kaya check that. Ito yung legal basis natin, no? Except for banks, which shall be governed by the new Central Bank Act, no? Otherwise known as the PDIC code. Every corporation whose charter expires pursuant to its articles of incorporation is annulled by forfeiture, or whose corporate existence is terminated in any other manner shall nevertheless remain as a body corporate for 3 years after the effectivity of the dissolution, no? For the purpose of prosecuting and defending suits by or against it and enabling it to settle and close its affairs, dispose of and convey its properties and distribute the assets, but not for the purpose of continuing the business for which it was established. So meron pa siyang, kahit wala na siyang buhay, meron pa rin siyang mga transactions na i-honor ng batas natin, no? Siyempre, no, if meron pang mga outstanding claims yung corporation or against the corporation, dapat ituloy yung mga yon, no? Kasi magiging parte ng liquidation. Liquidation is identifying the assets, converting them into cash, paying off your obligations and liabilities. Kung may mga taxes, kailangan din bayaran yun. Then, kung meron ng maiiwan, yun yung mapupunta sa mga stockholders. At any time during the 3-year period, the corporation is authorized and empowered to convey all of its properties to trustees for the benefit of the stockholders, members, creditors, and other persons in interest. Pwede daw ibang tao ang mag-manage nung liquidation. Tatawagin mo siyang trustees. Pwede yun. After any such conveyance with the corporation of properties in trust, no, for the benefit of the stockholders, members, creditors, and others in interest or interest which the corporation had in the property terminates. No? Napasa mo na siya sa trustee. The legal interest vests in the trustee, and the beneficial interest in the stockholders, members, creditors, or other persons in interest. Alam naman ng mga trust na hindi sila yung may-ari ng corporate assets. No? Pinangahawakan lang nila to bilang trustee and for the benefit of the stockholders, members, creditors, and persons in interest who are all waiting for the results of the liquidation. Except otherwise as provided by sections 93 and 94 of the Revised Corporation Code, upon winding up of the corporate affairs, any asset distributable to any creditor or stockholder or member who is unknown or cannot be found shall be escheated in favor of the national government. So kung meron ng specific property na ibibigay sa creditor or sa stockholder or sa member pero hindi siya malocate, cannot be found or hindi siya kilala, unknown siya and cannot be found, it will be escheated. Kung sabing escheated, mamanahin ng gobyerno. Kukunin, babawiin. Not really babawi kasi din naman sa kanya yan. Pero i-award sa government. I-award sa government. Parang manahan, di ko alam kung sino makakapag-tax to sa inyo. Kapag walang tagapagmana, yung isang tao na namatay, na wala siyang ascendants, parents and ascendants, wala siyang children and descendants, wala siyang mga kapatid, wala siyang relatives up to the 5th degree wala siyang relatives up to the 5th degree, then it will be the government who will inherit the properties. Ang tawag din ay escheat proceedings. Except by decrease of capital stock and as otherwise allowed by the Revised Corporation Code, no corporation shall distribute any of its assets or property except upon lawful dissolution and after payment of all its debts and liabilities. Siyempre, bawal yan under the trust fund doctrine. Trust fund doctrine. Hindi mo pwedeng i-distribute yung mga assets mo kung hindi ka naman nag-dissolve. Diba? Ba't mo siya pinamibigay? Nag-dissolve na ba kayo? Hindi pwede. Oh, that's it. No? That's it. So, those are the matters pertaining to the dissolution of a corporation. So if you have questions regarding the discussion in this lecture video, you can type them in the comment section below. Wow. Or if you are shy, you can send a message sa ating MS Teams classroom. Okay? Thank you for watching. Thank you for listening. And paalam. Goodbye. Bye-bye.